Ciao a tutti. Hello, you proffers out there. Uh, this is Prof Jo, and this is Prof Jo Explains, and I'm so glad you're here. And I'm going to go right into this. I don't know how many of you saw all or part of the trial today. It was actually pretty interesting, and a lot of things came up. So I'm going to head right into it and see if I can get through most of it and then see what questions you might have. This is a live recap, so I'm really pleased that I'll be able to deal with your comments and interact without trying to pay attention to the trial at the same time. So the first I want to start with the judge rulings today. Oh, thank you. What is it? West Coast Magic? That's very nice of you. In any event, I want to start with the judge's rulings. One, the Fausto, that's Anna's, the person with whom she was having the affair. There was a lot of argument pre-trial and then the first day of trial, and then again today, about the text messages between Fausto and Anna. And the defense was able to get some of those text messages in, and the ones that the defense was able to get in suggested that the marriage was not in trouble, that Anna planned to stay in the marriage. The Commonwealth then argued that that was giving a skewed picture of the marriage, and it should be able to enter other of the text messages that would put it in more context, including one where Anna said to Fausto, "My life is completely messed up." And there was argument about it, and the judge said she thought some of them were relevant, at which point the defense said, well, as far as we're concerned, we'd rather have all of them in than have a few selected ones from the Commonwealth. And so that's where they ended it. All of them are going to come in. And it was pretty clear from the judge's questions that she thinks some of them are not going to be relevant to any issue in the trial, but they're all coming in so the Commonwealth is getting what it wanted. It will be able to provide context. Then what's still not decided is the issue of whether the fact that Brian pleaded guilty or pled guilty to the two other charges will be put before the jury. The defense wants that in. The defense wants to show that he took responsibility, and therefore they want the pleas in. The prosecution does not want them in. The judge has not decided yet, but she did indicate that she's a little concerned about it because she is worried that if the information, excuse me, that he already pled to two other charges comes in, that it may lead jurors to think, well, he's being punished now already. We don't have to worry about finding him guilty of murder one. So it sounded to me as though she was tending against letting the evidence of the pleas in, but she has not yet decided. Then we had information from somebody who's an insurance. He's not a salesman. I don't remember what his title was, but the defense tried to, or the Commonwealth tried to get in through him. There's a question there. Let me just take it from Patricia Barnhart. Yes, the boyfriend is going to testify, I'm sure. Excuse me, prosecutor wanted to try to get in through that insurance guy. I'm going to call him Guy. The insurance guy, medical information that Anna was in perfect health, attempting to confront the defense claim that she just died of this sudden and unexpected death. And they had a sidebar about it. They actually sent the jury out, and excuse me, and the judge listened to the testimony that the insurance guy would give and what the cross was going to be. And she ended up deciding that he couldn't testify to the medical information, which is probably right. He's not a medical expert. He didn't have the medical experts. They went to their third party entity that takes care of all of that. And so the judge told the prosecutor, if you want to get in medical records, it'll have to be on rebuttal after we see what the defense case is. And she also pretty clearly suggested to the prosecutor, you're going to have to get somebody other than this witness to do it. What he did testify to was the way the insurance company decides whether you are a health risk or how healthy you are, the criteria they use, and also that on their criteria, Anna was the top tier. There are 39 levels. She was at level 1. The defense then did a little, they're all kind of sort of just chipping away at the foundation. One of the questions that is done on the telephone interview is they're trying to elicit, do you have a risky lifestyle? The example that was given was, do you bungee jump every weekend? If you have a risky lifestyle, then you go down you descend this 39 step what would I say, staircase, because you're more risk and you get a lower or higher rating, because the higher the rating, the worse. I think that's the way they said it. And so then the defense suggested that someone who is trying to get insurance might downplay the risky lifestyle to get a better rating. That seemed to me that was a useful thing, but I think if the jury thinks about it, it's not going to matter much, because if that's the thing that gets you the higher rating, by saying you don't have a risky lifestyle, one, we have no evidence that she did have a risky lifestyle, and two, that particular factor is irrelevant to whether you get in bed at night and die of some disease. The fact that you bungee jump shouldn't have any effect on that. But I still think it was a noble effort. And I thought, frankly, at a 30,000 feet level, that the defense did as best as it could, chipping away at the prosecution case. And I think in a couple of times, it really landed at least a little with regard to the prosecution case. Let's see if there are any other rulings that I want to mention that she said. I think that's it on the rulings. And I will get to where I think she landed as I go through this, rather than jump around. One of the issues is going to be whether Brian Walshe knew about the affair. The prosecution says he did, and that was one of the motives for the murder. He's claiming he didn't, but there's evidence that he knew that Anna was texting Fastow on December 31. The judge actually laid that out when the jury was not present, saying that the evidence was either he saw one of the texts that Fastow had sent, or that the text was coming in on Brian Walshe's phone, and he had said somewhere else that he was somehow getting some of her texts. So there's evidence that he knew, and there's corroborating evidence, because the dinner guest set up on New Year's Eve said that Anna spent a lot of the night on her phone texting. So that's going to come in, and that's helpful to the Commonwealth. That's one of the things the Commonwealth wanted to get in. I thought the defense did a good job with the Google searches, redirecting. You ask one question and then 4 or 5 different suggestions come up. And they focused on the searches that had murder in the caption. There was one that was murder, murder, murder. And there was one, what do you do with a body after a murder, which directly undercuts, of course, Brian Walshe's statement that he found her dead in bed and that he had nothing to do with it. But the defense queried the law enforcement officer about could he tell whether those queries were redirected queries from Google or one of the other search engines, or whether they were actually queries from Walshe. The officer said he did not know. Now, the officer had earlier testified that it was possible for him to determine whether a text or a question, a Google question, comes from the user or it's Google leading the user on. And so he could have looked for to find that out, but it was not something that he or the prosecutors had thought about or predicted. So they might have been able to get that evidence. They didn't have it. And so the defense scored a point there. There was also, the defense had the witness say that there was no evidence of computer tampering and no evidence that any information on the computer or data on the computer had been eliminated. Of course, the Commonwealth came back, or actually it was the detective, or what was he, investigator Guarino, Sergeant Guarino, I don't remember what his title was. But he said, yeah, but I didn't have the MacBook. And so that really did come back and, sort of bring us back to status quo ante here. As an aside, I thought the prosecution witnesses were very good. They were neutral. They didn't try to lean either way. And so they were, I thought, extremely effective. And so kudos to them. The insurance guy, when he was on the stand, the defense got in through him that people use insurance as financial planning. It doesn't mean that you're trying to get somebody to buy insurance because you're planning to kill her. And also that the pattern of the purchase of insurance was that Brian Walshe had tried 4, 5, 6 times to get insurance in his name, and his agent had tried to help him get it. But because he had those outstanding federal criminal charges, no insurance company would insure him. And then Anna Walshe got the insurance. There was a little bit of a to-do about that, because what the defense kept trying to get the insurance agent to say was Anna, applied for insurance because Brian couldn't. And the agent could not say that. He didn't have that information. He could say that doing it is financial planning. He could say that, maybe in other cases in his experience that happened, but he couldn't say that Anna had said that to him. And there was the difference. So that testimony did not get in. And I don't think the defense needs it, because what you do is say, on this date, this date, this date, this date, and this date, Brian Walshe tried to get insurance and he was turned down every time. And then on this date, Anna got the insurance. And then in closing, the defense can argue the inferences from that. So it's not important that it wasn't in the evidence. So I thought that was, a kind of a good thing for the defense. I mean, I think it helped. It's just chipping away at this wall, but it still was something that was effective. Then the divorce searches. Brian Walshe had searched, had a couple of searches, I think on the 27th of December, about divorce. One of them was a sort of a general question. The other one or two, there might have been 2 others. One was, what are the best states for a man to get a divorce in? And he learned that Massachusetts was the 3rd worst. And then another one asked a question about what was divorce like in Washington, D.C., obviously, again, particular to him. What the defense tried to suggest, again, saying that those divorce questions were redirected questions from Google or Yahoo. And they said that immediately preceding the divorce question, there was a question about a Katie Holmes movie. I don't know what the movie was about, but that then the divorce questions came up, suggesting that the Katie Holmes query was Brian Walshe's, and then the questions about divorce were generated by the Google redirect. I don't know that that's particularly effective, because 2 of those search questions, as I said, were, where can a man get the best deal? And, what about Washington, D.C.? But at least, it was an effort, and they can only do what they can do on the evidence. So I thought that was also very good. The question about the Google searches that mentioned murder, same thing. The defense said they were not him, or suggested, or what they did was to say to the officer, you don't know that he asked those questions about murder. And that was true. It's the same thing, that redirected evidence came up. They also tried with the text messages with regard to, does a body smell? This one I thought they didn't succeed on, and they probably shouldn't have tried, because they asked the officer, isn't it true that it wasn't until January 4th that a question came up about what do you do to mask a body smell? And that may well have been true, but what the officer said was, yeah, but on January 1, the question was, when does a body start to smell? And so then the defense lawyer said, well, but I'm asking about masking smell. But the point that he was trying to make was it was only until January 4th, then that query came up. So you can't, January 1 makes it look more like it had something to do with an intentional killing or deliberate killing. And, once the officers was able to point to equivalent kinds of text queries or Google queries, on January 1, I think it lost all its force. Then there was the police crime lab person, who I thought the most effective thing about his testimony was all the evidence bags that came in. And there was a growing pile, which had to have had a visual impact on the jury. And what I thought was particularly good, I don't know if the prosecution did it deliberately, but if they did, I give them 100 points or 1,000 points or however many points one should give, because they were all closed with red tape. And it was a great visual for blood. I mean, I really thought it was a great visual. And so there are the piles of bags, suggesting, look at all the evidence, and then it's the red tape. Great visual. So let me look at a couple of other things. I know I'm going really quickly, but I don't want to hold anybody up for a long time. I want to talk to you about the Massachusetts rule on submitting charges to the jury. We talked about it at the end of the day today, and I did get a text answer back from Margaret McLean, who's a lawyer in Massachusetts, and she was very kind to answer my question. I like doing research that way. Instead of spending hours tracking down law cases and looking at them and reading them and matching them up with other cases, to find a lawyer who practices in the jurisdiction and ask that person, it's a great way to do research. I recommend it. If you can find it, go for it, because you can save a lot of time. I don't mind doing the research, but I didn't have time yesterday or tonight or today to be able to do it. So before I get to that, though, I want to respond to a question that came up during the day from SK 57158. And the question was, aren't defense lawyers supporting perjury if they present a divorce such as the one that the Walshe defense is, which I think we all agree is a ridiculous defense. And I addressed this, I think, last night on Surviving the Survivor, but I want to do it again. There are two things that are going on here. One, obviously you cannot suborn perjury as a lawyer, but on the other hand, you're supposed to do your best effort for your client. Your client can provide this defense, however ridiculous it is. He can provide the defense, but he doesn't have the knowledge of the evidence rules, the information about how judges rule, about how you present evidence. He needs a lawyer to be his spokesperson to get that evidence out. And therefore, the lawyer's obligation, so long as there is a basis to believe, or let me put it the other way, no basis in the facts or the evidence to disbelieve, then the lawyer will present the defense that the defendant claims. Now, the lawyer may try to talk you out of it because it's not a smart defense, but it isn't an ethical issue. In this case, when Brian Walshe says what happens in that bedroom after the dinner guests left on now New Year's Day, there's nobody who can contest factually that what he's saying is not the truth. We may all say it's unbelievable, but that's different from saying there is evidence that shows that it's a lie, evidence in the record that shows it's a lie. So the defense lawyers then can present this defense that is the defense that's what he said happened. They don't have to believe um, that it's a great defense or that it's even a believable defense. What they have to believe is there's nothing in the evidence that demonstrates it's a lie. Now, the suborning perjury part of it is if you believe or have knowledge that what your client will testify to is a lie, then you cannot prevent the client from taking the stand. He has the right to do it, but you are not permitted to cooperate in the perjury. And that's when you get narrative testimony from defendants on the witness stand. The defense lawyer puts the defendant on the stand and says, have at it. And then everybody knows that the extraordinarily high likelihood is that client is going to be perjuring himself. But the lawyer has not participated in it, and that's where the ethical rules come out on this. So I hope that goes some ways to clearing up why the defense lawyers are able to mount the defense that they're mounting. They're doing their best for their client, and even if they think it's a ridiculous defense, it is not one that you can point to things in the evidence demonstrate that it can't be true. We can certainly say, we don't think we think beyond a reasonable doubt that it happened, so we don't believe you. But it's not that you're pointing to something that you say demonstrates that it can't be true. So then I'm going to get to this Massachusetts rule, but let me take some of the questions. Since there are questions here, I'll do that first. So, ain't no hollowback girl. She was with me all day today. Thank you very much. And I hope you've subscribed, because that would really help the whatever they call it, the algorithm, which I don't understand. I just know that it helps and it doesn't cost you anything. So it's a win for me, and 2 or 5 seconds for you. Do I know if a child psychologist and officer questioned the Walshe's 6-year-old? It's been done in other trials. Kids see and hear a lot. I do not know, and I doubt it happened, but I don't know. I don't know the answer to it. So are there other, okay. Do I think Brian Walshe will testify in narrative? I don't know. I think that the way that the defense lawyers has presented the case so far, that they do not believe that they know that it's perjured testimony. And so I think they may well ask him questions. If he testifies as a narrative, what will be a doozy of a direct and then a cross-examination of him will be even doozier. I just made up a word. I'm so proud of myself. Because there's so many ways that they're going to be able to get after him on cross-examination. It's just going to be amazing. That's all I can say. And there were some questions today, actually, about the evidence. She's the boots are bloody, the jacket is bloody. So how could she have been in the bed? Which is what his story was. But you got to remember, he told 2 different stories, and they're not going to jibe, which is why. The second story is ridiculous, but he also has to square what he did when he had the other story. So let me be clear about this. He started out thinking that he was going to say, and he did tell the officers this, that they went to bed at after the New Year's Eve dinner, and that she had this emergency real estate issue that she had to deal with in Washington, D.C. So he saw her at around 5:36 in the morning. The 6-year-old boy saw her at around 5:36 in the morning, and that she called an Uber and went to the airport. That was his story, and he kept telling it in those 4 interviews, that's what happened. But now he's being confronted with all this evidence. There's no evidence of any Uber or Lyft or any other way she could have gotten to the airport. Oh, and let me back up. And so then since that's what his story was, and evidently, from what we can tell, since it was bloody boots and the jacket and whatever, he did kill her Either that jacket was an indoor jacket and she was still dressed from New Year's Eve, or maybe she was getting dressed to leave with him, with herself, or with the kids, and that's when she was killed. So he gets rid of all that evidence, and that's the evidence of the, the bloody jacket, um, the towels, all of that. But that's all related to that. Well, not the towels, but a lot of it is related to the first story. Now, when there's evidence that she didn't ever leave the house, that she never got to the airport, that there's no evidence of any flight that she was on going back to DC. And there are the videos of him at Home Depot with $450 of cleaning supplies that he's going to pay for in cash, and all the Google searches about, how do you take care of a body that we know about. Now he changes his story, and now his story is that he went downstairs to clean up, which to me is another extraordinary thing. A lot of you out there are married or have significant others, and I wonder how many of you have your significant other or spouse, at 1:30 in bed with you, at 2:30 get up and clean up the kitchen on New Year's Day morning. But now his story is that he came back upstairs and she was dead in the bed. So all that other evidence that was his covering up what he had done with a story that said she had left, that's no longer working, is still out there. And he can't get rid of that, the evidence that's going with that story, to do this story. And he doesn't have time to start playing around with this because he didn't think of it at the time. This story comes up maybe 2 weeks ago. So he didn't have time to also bloody up, I guess, pajamas and robe or those sorts of things, and then go make another run to distribute those things in trash bags. And in any event, he now knows what he should have known the first time, that there are cameras all over the place. He's never going to get away with it anyway. So that's why the story, as you hear it, the silly story, is all inconsistent, which is why I think that the cross-examination of this is just going to be amazing. And then he also has to explain let me just stop because I could go forever on this. Let me see. It's Topcat 8877. What's my impression of the judge in this case? How would I describe her style? I like her a lot. I only have one criticism, and that is she goes from 9 to 4, which seems to me to be dilettante hours in a courtroom. We want to get this trial over. The jury is there. And for 2 days now, she's stopped at 3:30, 3:25. She plans to end the day on Friday at, what did she say, 2 o'clock? I consider those dilettante hours. We pay them money to do an 8 to 5 job the way most of the rest of us do. That aside, everything else I think she's done has been wonderful. And everything else, I think she's the best judge I've seen. She is decisive. She is quick. She clearly knows the law. She knows the evidence rules. She is prepared, so she knows what the documents say before she gets to court. She protects the record like no judge I've ever seen. Make sure that when they're talking about an exhibit, that not only do you have an exhibit number, but we know what the exhibit is visually, which makes it a dream for an appellate lawyer. She, every which way, she's very careful. At the end of any, certainly at the end of the day, but at the end of any long colloquy that they've had, she will ask both sides, do you have anything else you want to say? Do you have any questions? Prosecutor, do you? Before she moves on, cutting off those claims that, we had something else to say. In demonstrating that she's telling the jury, don't look at newspapers, don't watch podcasts. She does it in the morning, she does it in the evening, and she told them the first day, I am going to make you look at me and nod that you to the answer to each of these questions, and I'm going to make you say it orally. And she does that. And if you didn't hear her do it, and you're going to watch the trial tomorrow, watch her at the beginning. You'll see her head go, this way. And what she's doing is looking at every juror to get the assent both this way and orally to each of the questions. So that's only one illustration of how good she's doing. So now here I'm getting this Webster Carroll 5 saying she's confused or he's confused. If she just died in bed, according to his story, why was there blood? But that's what I'm saying is the issue with the two defenses. Plus, his second defense still has to, his second explanation still has to account for the fact that there are bloody towels and everything else, which, I'm presuming were used in the murder itself, and the prosecutor the same way, because they've charged him with murder one by assault and I don't remember the wording exactly, but it's physical, physical hitting, beating, I think might have been the word. And so there's going to be blood. And his story to account for the blood, because, the question was right. If somebody died in bed, you're not going to find blood. But he's got to account for the blood. And so his story is, this is a crazy story, that he found her in bed. She was dead. For all he knew, natural causes. But nonetheless, he panicked, thinking, I'm going to be suspected of this crime. So what I should do is chop her up, put her in bags, put all the evidence bags, clean up the house, clean up the car, throw everything in the trash. So that's why you have the blood combined with the story that she died in bed. So, all right. Okay, here's another one from Stuart. If it's not Stobhill, could you send me something that tells you how to pronounce this? Is it a long O or a short O? Okay, because I would rather pronounce your name correctly if I can. Do I think the jury will resent being in the dark about the location of the body for the majority of the trial? I'd feel frustrated. I'm not, think about it. If you're on the jury and you're just at the start, are you wondering about where the body is? I think if anything, if you think about it at all, you're going to expect that you're going to find out. So I'm not sure, because that they're wondering right now. And if they're going to resent what they're hearing, there's a whole lot more they could be resenting than that, I think. It's a Glaswegian name, but that doesn't tell me how to pronounce it. Send me another chat and ask me if I'm pronouncing it correctly. And then if not, I'll try another. And maybe by trial and error, I'll get to a right pronunciation. Okay, Jennifer King. Do I think he tried to get hold of Nick Casadas for a better story? I don't understand that question, so I can't answer it. But I think any story would have been better than the one that he used. So that would be my answer to that. I don't care who he went after. Any story would have been better than the one he used. So let me talk, because there's not a question up at the moment. Let me talk about the charges and what we had talked about at the end of the trial today. And that is, thank you. So it's Stop. Thank you very much. Okay, I got it right then. Stuart Stobhill. He's only been charged with murder one. And the hardest part of the prosecution's case will be to show that he deliberated or premeditated murder one. There's a lot of evidence of what he did after somebody was dead. There's not very much showing what he did before the person was dead. And in fact, we can't even be sure that the murder happened between 1:30 and 4:30. 1:30 when the friend had left, and 4:30 when those Google searches began. I mean, it's theoretically possible that he was so angry at her that he did the Google searches and then killed her. So we can't even be sure about that. But it's probably that 3-hour window. He didn't plead to anything. He pled to the two other counts. The best guess is that the Commonwealth would not give him a deal moving murder one to murder two. They think he's a cold-blooded murderer. They think what he did to her body after she was dead is just deplorable. They think that he killed her that way, that it isn't simply that the blood on the hatchet and the hacksaw and the broken knife and the blood in the basement all happened after maybe he strangled her or something else. They think he went after her with those things and then continued on to dismember her. And so they weren't going to give him a deal. So not having a deal, he's going to be at trouble. He's not going to plead to it. He might as well go to trial and, see what happens. He did plead to the other two counts, as we know. And so they're out of the picture. And I talked a little bit about the defense wanting the jury to know that he pled so they could say, boy, he took responsibility here. But in any event, we don't know whether that's going to come in. But it's only murder one. And the question that came up was, supposing the jury can't decide on murder one, can it convict of murder two? And that's what we were talking about today. Once the case is submitted to the jury, once the jury is charged on murder one, it's going to either acquit, convict, or hang on murder one. It can't go to murder two. Now, let me do a side thing here. There's a theoretical possibility that the jury could come out and say, we're hung on murder one. And the judge could ask the prosecutor and the defense if they are willing to have it move on to murder two and let the jury consider it. It's theoretical. I don't know if in practice that would happen, but I want to at least address that. But if only murder one goes in, that's all the jury can decide is murder one. They can come back if it's hung. The prosecutor can then retry for murder two, but he will have his chance to get Brian Walshe on murder one first. Jurisdictions differ on what should happen on whether the other charges go to a jury or not, even if they're not charged in the indictment. There are a few jurisdictions that say, and the way it has to go is, for all of these, that you have to say that there is a way on the evidence that you can conclude that a jury could acquit on murder one, but convict on murder two. And if that's the case, now we're in the world I'm talking about. And in that world, a few jurisdictions say, if that's what the judge concludes, then she can charge murder two to the jury. So they have both of the charges when they go in to deliberate, notwithstanding what the prosecutor wants or the defense lawyer wants, because we as the public also have a right to see justice done and to see the efficient administration of justice. Other jurisdictions say that can happen if both the defense and the prosecution agree. Let's let murder two go to the jury also. So then when you get to the point at closings and the judge then instructs the jury, the judge would instruct on murder one and murder two. And it's done because both sides agree. Still, other jurisdictions say you have to have the agreement of the defendant to do that. It doesn't matter what the prosecutor wants, or even if the judge would agree to it, you need the agreement of the defendant to do it. And I was saying today, I did not know what position Massachusetts took on this. And as I said, nice to have research when you've got a lawyer in the jurisdiction who can do it. And this comes from Margaret McLean, who actually has just started her own YouTube channel. And so you might want to seek her out. But anyway, she says, and here I'm going to read this a little. In Massachusetts, the jury can only consider lesser charges like second-degree murder or manslaughter if with the prosecutor or the defense request it, and the judge also has to approve. And there has to be rational evidence supporting it. Now, that would be, you've got to be able to show that, it's just not a will-o'-the-wisp. There's actually evidence there. Now, to make it clear what I'm talking about with regard to murder one, murder two, the easiest way to think about lesser included is the most serious crime has 4 elements, A, B, C, D. The next level crime has 3 elements, A, B, C. The one under it has 2 elements, A, B. In that schematic, if you're convicted of A, B, C, D, you necessarily have had to commit the crime that was A, B, C and the one that was A, B. It's impossible because the elements up here include the ones down there. That's why these are lesser included. And in those cases, you start with a high one, it would be murder one. You go to murder two if they can't convict on murder one. And I don't think in this case, I don't think the defense is going to want it. Well, I don't know. I take that back. I don't know whether the defense would want it or not. But I don't think the prosecutor wants any lesser included, because if the prosecutor was so inclined, he probably could have made a pretty good deal on a plea bargain before this went to trial. So anyway, that's that rule that we were talking about. That's my summary of today. For those of you who watched yesterday and today, today went much more quickly, much more efficiently, and I thought the Commonwealth case was really very powerful today. That image of those bags with all those red tapes, I thought was really powerful. It was just a terrific visual. And of course, they have so much good evidence to play with. So now we have Cooler by the Lake. Do I think that Walsh would have been better off not pleading to the lesser charges, just denying everything? Uh, they obviously decided that his best bet was to get those out of the way. I think they thought that if they did that, they might be able also to keep out of the way all those Google searches. But I mean, that was a thin reed to grasp on, that the judge was going to keep those Google searches out. I think his best bet, frankly, would have been to say, yes, I did it, but I didn't premeditate it. We were having an argument, and in heat of passion, I hit her, and then I decided to cover it up, which would probably be manslaughter. Why he didn't try for that as his defense, I don't know. It may be that Brian Walshe, along with all these other defendants, Sarah Boone and let me think of Donald Adelson and Charlie Adelson, I mean, I can go on, just think they know better. They think they can persuade a jury of anything. They think they're so convinced they're right that I think he may join right in with them and think, I'm not going to plead to anything else because I'm going to win and they're going to acquit me of murder one. And he's a con artist. I don't know that he's a really good con artist, because when he tried to sell those Andy Warhol paintings as originals, he got caught very quickly. But he may think that that he's going to win and that he knows better. So are there other questions? Because I promised I wouldn't hold everybody up a long time, but I wanted to give you my view today. And did I see Judy saying, I thought I might have seen her go by AA Legal Focus. She has, I think most of you know of her channel, and I do. If you don't, I really recommend that you go over and watch it. She's very, very good on the law. She brings in very interesting guests, and she does some very, very funny comedy skits based on some of the cases. And she's a really good actress. I mean, she had another career in front of her when she when she decided to be a lawyer and said, oh, there you are. She's there. So hi, Judy. And see, it's a legal focus. If you haven't tried her channel, I do recommend that you give it a whirl. In fact, we may see her in a bikini soon, because she's got a bet about Wendy Adelson being charged. Was it before Thanksgiving? And she promised to wear a bikini. I think she may have to correct us, but I think on her channel. And, she said she's been getting in shape for it. Apparently she's got less confidence that the indictment will come before Thanksgiving. But you don't normally see a lawyer on one of these podcasts do that. So maybe she'll, do the whole episode showing how well she knows the law in a bikini, and showing that she's really multifaceted in the way most of us are not. So, all right, let me get another question. Do we know what witnesses the defense will call? I am sorry, I do not have the witness list. I like to have a witness list for both sides, and I just don't have it now. As I go forward, I intend to have the indictment, the arrest warrants, and the witness list for both sides. I'd like to have all the motions, because then I'm in the best position to respond. So I don't know what the witness list is. I am confident that Walsh will have to testify, because there's no other way his story of what he found in the bedroom can come in. There's no one else that can testify to it. I am confident that Fausto, the man with whom Anna was having the affair, will testify, because of what we've heard already in the trial. And I'm reasonably confident that Brian's mother will not testify, because she's been sitting in the courtroom, and that usually means you're not going to be a witness. She Brian, also one of the other claims that the defense made was that they weren't in financial trouble, that they had all these properties, so they didn't really have to go after, he didn't have to kill her to get the insurance money. It seems to me that's a hard one to do also, because he owes, what, $450,000 in restitution. His mother was paying the rent on the house they were living in Massachusetts. So if he's financially okay, I don't know why his mother was paying the rent. And so I don't know that will work either. Okay, Dawn 64. Why would they start this trial when he was about to be sentenced on his federal charges? Thank you for the hard work. We found out today that he was sentenced a few months ago. And you don't want to, oh, good, that's great. Thank you so much, Gen X to the seventh power, putting up the link to Judy's channel. If we always waited for one trial to be fully over, including sentencing, before the next one began, we'd have a lot of delayed trials. And so the trial was over, so there was no conflict in terms of him trying to be in two places at the same time. So I don't see any reason why they couldn't go forward. So, any other questions about today? It looks like you're questioned out. My students in law school used to say, when I got on one of these roles, I would do so much that they just couldn't even get a question in because they were so overwhelmed. So if I did that to you, I don't know whether to apologize or say I did my job. You'll have to decide. I missed that. Can that come back up? I was busy talking, which I do a lot of. Okay. Thank you very much, Moo Judy 99. I hope it was responsive to the questions. And I've got some, episodes coming up that I had taped, several on the Adelson trial, and one on Maddie Soto, which is a case that just bothers me whenever I think about it. Okay, let's do this. Does Brian Walshe have any parental rights? Now, this is taking me into an area of law I don't know a great deal about, but I believe that he does. He hasn't, well, he would have, depends on what you mean by parental rights, but certainly he hasn't been convicted of anything yet. He's presumed innocent until he's convicted, so he's got parental rights now. Now, he's in jail, so he's obviously not going to be able to assert custodial rights. He may want to have something to say about who has the children while he's in jail and through the trial, and maybe after he's sentenced. The court, I believe, would listen to it, but they don't have to accede to his wishes, given his situation and his character. But I think he'd have the opportunity at least to say something. Her mother is in Serbia, and the information that I did read before was that she was trying to get custody of the children, but of course she's in another country. And one issue would be the reluctance of a court here to let the children go to another country where it would be difficult to get them back if in fact, some crazy thing happens and he's acquitted. So I don't think that they would be really receptive to doing that. And in any event, the story I saw said she had visa issues, which suggests to me she was trying to get here and has been having difficulty doing that. It doesn't appear that Brian Walshe's mother has tried to get temporary custody. If she did, she didn't get it. So I think the last I heard, they were in state custody, which is a real, but the kids are always the innocent victims of all this. It's just, it's just terrible. Okay, what was his federal sentence? I think I can remember this, 37 months. Now, I don't know how much of that he's going to have to serve, and he's got restitution of, I think it was $454,000. So that's his sentence. All right, I will wait a ticking of 3 seconds to see if there are any more questions. Otherwise, I'm going to say good night, and it will be nice to see you tomorrow. And if you're not subscribed, as I say, it only costs you about 5 seconds to do it, no money, and it would help me a lot on the algorithm. So thank you. Okay, and there's somebody, this is Jet Brigger. Is that what it is? Brigger, yeah. Oh, it's not a question. It's just saying he or she is happy that I have my own channel. Thank you so much. And you heard me ask for a subscription to the channel. So if you are happy, the best thing you can do for me is subscribe and maybe hit a like, if the mood takes you. Ciao a tutti. This is Prof Jo at Prof Jo Explains. It was fun doing this recap. I'll be doing the trial commentary tomorrow beginning at 9. And I'll see you then, or hopefully I'll see you some other time. So long. And all my proffers, thanks for joining in.